Hi, everyone. Thanks again for joining us for another episode of the Fen Talks podcast. On today's episode, we're featuring David McCarville, one of Fennemore's Trust and Estates directors, and we're diving into the really interesting topic of lessons learned from the rich and famous as it relates to trust and estates. David, you wear multiple hats in the business community. And for those that haven't had the opportunity to review your background or your bio, would you mind just sharing a little bit more about who you are and what you do, and specifically your role with Arizona State University as an adjunct professor?
Yeah, thank you very much. So I'm a director here in the Trust and Estate Planning Group, and I do a lot of work with clients across many different industries in helping them manage their wealth and wealth distribution. The adjunct professor work I do at ASU started back in 2017. I started going to lunch with Gary Marchant and a group of lawyers at ASU Law School. He would invite people to come in and listen to presentations on blockchain technology and cryptocurrencies. And that was very fun and exciting and interesting. And towards the end of that year, he said, look, I'd really like to offer a course here at ASU Law School on this topic, but I can't do it by myself. So would anybody volunteer to do it? And I thought, well, this is a good way to learn more about it. And if you have to teach someone something, you're going to learn more. So I've been doing that along with Gary and Bryce Suzuki from Snell and Wilmer. We've been teaching that class in the fall since 2018. It's been incredibly fun and interesting. We've learned a lot. The students are great at ASU Law School, and they're every year becoming more and more familiar with the topic. And we've been able to get some really interesting guest speakers in. I think it is something that I'm paying attention to for my business because my clients are impacted by changes in the financial services industry. And that is a main focus for this technology. And it is changing the infrastructure of the financial services industry. So it's interesting watching how much has changed in the last 3 years and how much more will change going forward. I think it has direct impact on us as attorneys, and even under the ethical rules, we are required to stay abreast of technology development. So I feel like this is a nice thing to have, and I enjoy speaking on the topic, and I do present on the topic pretty regularly. So if anybody listening would like to hear a presentation on the topic, I'm happy to do so.
I know our firm values having team members that are out there in the business community and helping the next generation of lawyers through your work that you're doing with ASU, I think is really awesome. So hopefully for those tuning in, you don't have to be ASU alum or an ASU fan, although go Devils, I am myself. And hopefully that means none of our U of A friends are, tuning out here, because I know David has some really great insight to share with the rest of the business community. So David, those individuals that are not familiar with trust and estates, let's start there. What is a trust? Would you mind just kind of covering everything from a high level?
Yes, absolutely. So it is an area where there's a lot of misunderstanding. A trust is really just a contract. So if you can think about it that way, you can understand that this contract will govern how your assets are held and how they're distributed. And there are two general types of trust. You have a living revocable trust, which I recommend for almost all of my clients, and anybody listening to this, if you don't have a living revocable trust, do think about getting one because it helps keep you and your estate out of the probate court, both during your lifetime if you're incapacitated, and then of course we're all going to die. So after you pass away, it will make things much more efficient for your family and loved ones. The other type of trust is an irrevocable trust, and there are many types of irrevocable trusts. And those assets, we generally put assets into those that the client doesn't need to live on. So if the client wants to set up a contract where they can push assets off of their balance sheet and say give to a charity or set aside for grandkids, they can do that using an irrevocable trust. And then we have to do a gift tax return to let the IRS know that these assets have left from the individual Social Security number and are now attached to a new EIN number that's associated with the irrevocable trust. And then that trust can be designed to meet the client's needs. Whatever it is that they want to see happen with that wealth distribution vehicle, we can do that in a customized way. And they can go on forever. So you can have a dynasty trust that basically lasts forever. As long as there are assets in it, it will continue to produce benefit for the beneficiaries of that trust.
Now, David, I know through some of the conversations I've been involved with, there are just some misconceptions around who needs a trust or a will. Everyone thinks, oh, you have to be rich and famous in order to have one. So can you help to set the record straight with that?
Yeah, I can. So I think it is also a state dependent issue. In some states, especially back east, they really don't have a probate process similar to ours. So in those states, it's not common for a lot of people to have trusts. And here in Arizona, we have a lot of transplants from other states. So at first blush, they think, well, it's not for me if I don't have, an estate tax issue, which is for the very wealthy, then I probably don't need a trust. It sounds too complicated. But the reality is that if you don't have a living trust here, and for instance, if you have equity in your home and you don't have a trust that owns the home, then a probate will probably happen at some point. And usually what we see is with elderly couples, they'll own the house as joint tenants, right of survivorship. One of them will get ill, the other one will take care of that one, and then one will pass away, and the other will usually pass away shortly thereafter. And when that happens, when they're both deceased, or if one is deceased and the other is incapacitated, say they have Alzheimer's or dementia, there's no way to sell that home without having it in a trust and transferring title from a trustee to a beneficiary, or going to the probate court and getting a court order that says this person, whoever that person is, a son or daughter or a friend or loved one, can come in and become the conservator if they're alive to manage their finances, or they can be the personal representative, which is what we call executors here in Arizona. And they would have legal authority to transfer those assets. And why that's important is because title insurance needs to be issued when you transfer home ownership to somebody. And the lawyers of the title insurance companies do not like to take risks. So they want to have either a current owner who has capacity sign the transfer, or they want a court order appointing somebody to have legal authority to make the transfer, or they'll recognize a living revocable trust as a instrument that holds ownership, and therefore the successor trustee who's designated in that trust document will have legal authority to transfer the asset. And that's really the key here. Anytime you're dealing with a third party who has control over the transfer of those assets, like a financial institution, or in this case, a title insurance company, you have to make sure that you meet their in-house counsel's requirements to have legal authority. And that's really what we try to do here is try to make sure that our clients do not have to go through additional hoops later on through the probate court to transfer assets to their loved ones. So we're basically taking care of the probate work up front. That's one way to look at it.
Yeah, I appreciate you kind of going over that. I'm sure that answers a lot of individuals' questions, but for those that are tuning in today, we have this weird obsession as a society that we love to follow what's happening in the media, what's happening in Hollywood, and we often look at what's happening with the rich and famous. So curious, as it relates to everything that you do in the trust and estate space, what are some lessons that we can learn from those individuals and their experiences?
Yeah, I think there are a lot of good lessons to draw there. And, celebrities and rich and famous people are people too, right? And so they also make mistakes. And that's mostly what we see when we read an article about a rich and famous person who's passed away. We start to see, well, they may not have taken as much care with their estate planning as they should have, which is unfortunate because that they could afford the best legal services, which makes me wonder why they didn't do it. And I think, there are probably many reasons why they didn't do it. But one example would be Jacqueline Onassis Kennedy. She actually did a great job. She had a living trust and she had her assets properly titled. She had another irrevocable trust and gave her kids opportunities to give to certain charities that she had identified. And she was able to set out her estate plan very nicely and took care of it. And I think that's really more of the exception. We see situations like James Gandolfini. When he passed away, he had a trust, but he also had a last will and testament, and he had some assets in trust and some not in trust. And what happened there was a probate on his last will and testament. And of course, the media got a hold of it because it was public record. And so there were a lot of privacy issues there, but also there were a lot of tax inefficiencies. So for clients who are wealthy, understanding estate taxes is very, very important. And the estate tax regulatory framework shifts all the time, and it changes based on who's in charge in Congress and the White House. And so we've seen tremendous changes in the estate tax exempt amount. And these wealthy celebrities who do not do the proper estate planning end up paying 40% of every dollar that's over the estate tax exemption to the IRS. And that money is due and payable within 9 months of date of death, which can cause a lot of problems when you have illiquid assets. And so it's a really important thing to think about. One other celebrity that's in the news lately is Britney Spears, and her conservatorship with her father acting as a conservator has been in the news cycle for quite a while now. And I think that highlights another important issue, which is mental health, because while Britney Spears is a great artist and a performer, and she seems to be doing better health-wise now, it was determined by the court that she really did not have the capacity to manage her finances. And that's what the conservatorship does for her. And so I think that's an important thing to keep in mind too, because when people hear the word incapacitated, they oftentimes think, well, I'm not incapacitated and this person isn't incapacitated because they're talking to me. And in my experience working with incapacitated individuals in the court system, they don't appear to be incapacitated in the first 5 or 10 or 15 minutes of conversation. You can talk to them and have a good conversation. But when they start to repeat themselves and when you start to realize that they're not managing their finances, that they're susceptible to being taken advantage by others, those are red flags. And that's where you really should be concerned. If they don't have a trust and they don't have assets in trust, you're looking at a potentially very costly and time-consuming conservatorship process to try to protect them from, those parties who would prey upon them or from just mismanaging their money. So, many examples of different celebrity mistakes out there, and we could talk for hours about them, but those are just a few.
Now, I think it's interesting, as you've mentioned, mental health, and mental health is a hot topic of conversation. May is Mental Health Awareness Month. And, 2020 brought to light the fact that there are probably a lot more individuals that do struggle with mental health related items. So curious, you had mentioned just, a little bit about how the Trust and Estates Group has worked with those individuals and helping families with dealing with this. You don't have to be a part or a member of the rich and famous in order to have family members that struggle in this capacity. So it happens to everyone. So David, would you mind just shedding a little bit more light in that respect?
Yeah, so mental health care power of attorneys, we first started seeing them here in Arizona around 2010. Before that, you would have the more general healthcare power of attorney, which really didn't have any specifics about mental health care issues. But for clients who have mental health care power of attorneys, what they are able to do is lay down some advanced directives for their loved ones on how they would like to be treated if they do have a mental illness. So they can state specifically treatments they do not want to have, such as electric shock therapy or others. They can state treatments that they do want to have. And I think what we're finding now from the medical research is that mental health is impacted by a lot of things that we can control, like sleep and diet and exercise and having a community around you. And then there are some things that you can't control, right? So some people have very serious mental health issues like bipolar disorder or schizophrenia. And, for those clients, if they can do a mental health care power of attorney when they're feeling well, they can reduce a lot of the burden that the agent who's going to have to take care of them when they are having an episode or incapacitated, they can reduce the decision-making burden on that agent. I think that's the real gift of estate planning, is what we're trying to do here is alleviate some of the burden on those decision makers. And another document that's come into use lately is a document where the client can state, if I have Alzheimer's or dementia, then please, feed me the foods I want. If I refuse to eat, then I either do or do not want to be force-fed or force-hydrated. And I think that's super important too, because you put yourself in the shoes of the son or daughter or friend or family member who's trying to take care of this person, and that decision has not been made in advance. They're going to have a very difficult decision to make, and they're probably going to not please everybody who is concerned about that person, right? They're probably going to make a decision that someone's going to disagree with, and that kind of strife can really tear a family apart. So having those decisions down, in writing in advance is a really nice gift to give the person who is going to be taking care of you in those situations. So it's an important thing to have in place.
I would love to pick your brain a little bit more about the process of just getting started. I'm sure there will be a couple individuals that tune into today's episode and they're like, wow, I probably should do something. So if they're ready to take action, what does the process traditionally look like?
Yeah, well, if they're ready to take action, then that's the first step. And I think what I would recommend to them is take a pen and paper and write down what you know right now. So if you know who you want to be the guardian of your children, if you have minor children, take a pen and paper and write that down and sign it and date it. Under Arizona law, a holographic will is just that, a pen and paper, handwritten document that's signed. You don't need a notary or a witness for that. You can do that at any time. And that alleviates a lot of people's concerns when I tell them that, because I do get calls from young parents who are getting on a plane and they're thinking, oh my God, what if something happens? Who's going to take care of our kids? And we don't want this person taking care of them, or they have specific concerns. So I tell them, just take a pen and paper, write it down, sign it, do not type it. You have to write it out. But if you can do that, that's a valid holographic will, and it will stand up in court. And I think that's the first step. So do that. And then after that, start talking to friends, get a good referral for an estate planning attorney, and start the process. It is a grind. I try to wrap it up in 3 to 4 meetings, and I try to do it week to week if possible. Schedules depending. But now we have more tools than ever. We can do a lot of this like you and I are talking now over Zoom. So for clients who are super busy and maybe 2 working people, they aren't in the same place at one time, or they don't want to get a babysitter, we can do meetings like this and make progress. And then we can sign in person. We can also sign online. We have a remote online notary law that passed here in Arizona. So these documents can be and have been validly executed remotely and online as well for clients who are interested in that, which is generally younger generations. But the process is getting easier. So that's the good news. But just start taking steps. Yeah, that's what I would say.
Some great insight there. So David, as we look to wrap up today's conversation, is there anything else that you'd like to leave our audience with?
Yeah, I think if you're thinking, responsibly about your family and how to take care of them, just like going to work and earning money for them and making sure that they're taken care of, you want to make sure that you have some sort of estate plan in place. And, if you're married, you want to get on the same page with your spouse about what it is that you want to see happen. And do take the time to go through it. I know it's difficult for some people to think about, but if you think about what you're giving to the people that you're going to leave behind, it's definitely a worthwhile pursuit, and you will feel great when it's done. It's one of the things that I really enjoy about this part of the law, because sometimes when you're in litigation or a contract, it may be done and they're happy about it, but it's usually not the greatest experience. But when you take care of an estate plan for a client, you can see the relief on their faces, and they tell you, I have much more peace of mind now. It's a very satisfying thing. So keep that in mind as you're working through the process. If you're out there working on it, that you will get through it and you will feel good about it when it's done.
All right, David, well, appreciate you taking the time to shed some light and some insight as it relates to trust and estates. So my only closing thought for those tuning in today is go Devils.